The problem is at this point there is no factual basis whatsoever to justify their demand. Okay?
But some would argue that the state is not, that they're supposed to conduct elections in an open and transparent way, and keeping that code in secret means the public cannot actually observe
But that's
how
your
it's
point
done.
of view. That's not the legislature's point of view. The state has already set policy, and you have every right to go across the street to the legislature and advocate that position and change the law.
Ironically,
but the law is what it is, and I'm not going to argue.
Ironically enough, with this catch-22, the legislature gets elected by those machines.
Oh, it's a long, long rope they used to hang you soon, I hope. And I wonder why this hasn't happened. Why? And I think about the dirt that I'll be wearing for a shirt. And I hope that I get old before I die.
My name is Miguel DeGrandy. I represent Election Systems and Software. Your Honor, we're not here to have a political debate about paper trails, about verifiable voting systems. This case is only about an election contest in the 13th Congressional District. And the motions that are the subject of this hearing present a narrow issue as to whether a private party under these circumstances should have the right to defeat the statutory rights afforded to my client and the interest of the people of the state of Florida in maintaining exclusive access to certain sensitive information within state agencies in order to preserve the integrity and security of its election systems. Now, the plaintiffs have told you that in the context of this lawsuit, they represent, and I quote from a previous proceeding, the voters of Sarasota County, unquote. I dare say that they do not represent the tens of thousands of voters that cast their votes and want their votes to be recorded because what they want is to have that election overturned. And indeed, they have inferred that they may represent the people of the state of Florida and the nation in this matter. Now, respectfully, Your Honor, the last time I checked, none of the learned counsel on the plaintiff's side were elected by the people. To my knowledge, the only parties entrusted by law and by the people to represent their interests are the state defendants in this case. So let me take a moment to talk about who the plaintiffs do represent. The federal plaintiffs represent the federal plaintiffs. However, they are represented by and aligned with special interest political organizations that have a well-defined political agenda adverse to DRE electronic voting systems. Mr. Coffey and his colleagues represent a client who lost in a close election. And if I may, Your Honor, I would respectfully tell you that more than anyone in this courtroom today, I know exactly how Ms. Jennings feels, because I lost my first election to the Florida House of Representatives by 1 vote. Now, unlike Ms. Jennings, I didn't sue anyone, I ran again and won, but it took me years to come to terms with the fact that what happened in that election is that I simply lost a close election in an open democratic process. That is what has happened here today. Now, to date, the plaintiffs have produced no evidence that they challenged the ballot layout prior to the election. They have produced no evidence that they challenged the results of the logic and accuracy testing performed on this equipment prior to the election. What the plaintiffs have presented are bare bones allegations, unreliable anecdotal evidence, and 2 expert declarations. In regard to the anecdotal statements, the evidence will show that these types of declarations are also inherently unreliable because there is a significant likelihood that honest, well-meaning individuals who believe they made a specific choice are prone to have made a mistake. Indeed, in the parallel test that will be presented as evidence in this hearing, Your Honor will see that even election department volunteers who were given a script of votes to cast and knew exactly the purpose of the test made mistakes. Turning to the experts' declarations, the evidence will demonstrate that the opinions they set forth are mere academic speculation. These experts do not present a specific theory as to why the equipment may have malfunctioned. They merely speculate that the high undervote rate may indicate that a malfunction might have occurred. Florida courts have clarified that even if there were some necessity to review trade secret information, the party seeking production must first show that the necessity for this privileged information outweighs the harm the disclosure would cause to the trade secret owner. Now, the plaintiffs have argued to you that no conceivable harm could result from disclosure of this proprietary information to these plaintiffs because they are not competitors of ES&S. That argument, Your Honor, is disingenuous at best. The plaintiffs' numerous public statements demonstrate that they have a well-defined political agenda that seeks to eliminate the use of DRE electronic voting systems in the state of Florida and other jurisdictions. It is clear that disclosure to these particular private parties has as much, if not more, potential for irreparable harm than disclosure to an ES&S competitor. Your Honor, the evidence will show that on many occasions, Florida's election systems have been thoroughly tested. For example, we will present evidence regarding the process and requirements for certification of voting equipment. In effect, the equipment, software, and source code are thoroughly reviewed in order to achieve federal and state certification. Post-election tests were conducted on November 28th and December 1st of 2006. These are the same parallel tests that plaintiffs have stated in their papers that were needed to be conducted with our equipment and software to determine whether they function appropriately. Before any election is conducted, certified voting systems must also undergo additional examinations, including logic and accuracy testing, to verify that the machines and software are working properly. Pursuant to Your Honor's directive, both candidates were allowed access and input in conducting those tests. In fact, they were even allowed to choose the machines that would be used in the December 1st test. And both of these tests demonstrated that the machines were functioning exactly as designed and that there was no malfunction. In fact, let me quote some of the findings detailed in the state's report of the parallel test results, which was released today. Quote, the parallel tests were successful in demonstrating 100% accuracy in recording the vote selections. Another quote, there are no indications of machine bias or otherwise voting machine faults that will yield rejected legal votes. Final quote, in summary, there is no evidence to support the position that the electronic touchscreens cause votes to be lost, unquote. Finally, Your Honor, the state is now in the process of finalizing the protocols and procedures to conduct their independent source code review by well-qualified independent experts. To the extent that a source code review may be necessary in this case, we respectfully submit that in balancing the state's interest and my client's legitimate statutory protected right in maintaining proprietary information confidential, the state's upcoming review should be the only source code review allowed in this matter. Now, the plaintiffs will probably tell you that the federal and state certification standards are woefully inadequate, that the independent testing associations that are certified to conduct these reviews for the government entities are incompetent, that the elections officials that supervise both the pre-election and post-election testing simply don't know what they're doing, and that only a review by these plaintiffs and their experts can be considered reliable. In effect, to find reasonable necessity in this matter under their worldview, one would have to conclude that all the independent tests that have been run on our systems are meaningless, and that only these plaintiffs have found the only experts in the nation that can examine computer systems and read source code. Finally, Your Honor, the evidence will also show that what occurred in District 13 is to a great degree inconsistent with a theory of computer malfunction and entirely consistent with the fact that the ballot layout and design in this race contributed to voter confusion. The evidence will also show that in 3 other counties, the same unusually high percentage of undervote, in fact higher, was reported in the Attorney General's race. And the evidence will show that even in precincts within Sarasota County, the undervote varied in a manner that shows correlation with some demographic features, such as age. This is also inconsistent with the theory that a computer bug or malfunction caused the undervote, unless, of course, computer bugs can tell the age of the voter that is using the machine. But there is no computer malfunction that would justify defeating my client's statutory interest and the right of the people of the state of Florida to maintain the integrity and security of its election systems, and therefore, the preponderance of the evidence will show that there is no reasonable necessity to disclose the requested information. Thank you, Your Honor.